Hi, everybody. This is Steve Maggi from SMA Law Firm. I have the pleasure of having with me today Mark Vanderlinden, a cross-border tax expert that I've known for many years, more than 20 years of experience in the US, including some of the big four, and now working on his own. Pleasure to have you here, Mark.
Thanks for having me, Steve.
So, we've seen this question a lot, and it comes up in all different scenarios, which is physical presence in the US. What triggers taxation? What doesn't trigger taxation? Does it matter what visa status or what immigration status you have, or is it just about physical presence? Where do these things come up, and what should people keep in mind going forward if they're coming temporarily or thinking longer term?
Well, for tax status, we basically divide the world in two parts. You are the residents and the non-residents. And with residency comes the obligation to pay tax on your worldwide income. That means income wherever you make it in the world, whether it's capital gains or whether it's salary or whatever payment, is going to be taxable in the residency country, in this case, the US. A non-resident may only be taxed in the country on the source income, meaning the income you generate from the US. So your US salary or your US capital gains. So a non-resident would not be taxed in the US on any income or gains that are outside the US. They don't fall into the patchwork. So the difference between the two and the fault lines in the US is fairly simple. It's a mathematical approach. There's a 182-day rule. And if you stayed some time in the US in the preceding years, you have to add back some days for that. But on average, if you're more than 182 days in the US, you're going to be a resident, which basically means you're going to be taxed in the US for the full year on your worldwide income. There may be some time you spend in the other countries. You get a credit for that or an exemption for that, so you're not fully double taxed, but it's not a perfect system. If you can avoid it, I would try to avoid it if possible. And another thing that's another layer lower is the same applies to state income taxes. States also have a residency requirement. If you're looking at New York, it's having a permanent home available for a certain amount of months. So you can end up in the situation that you're a resident for federal purposes, but a non-resident for state, or vice versa. Right? So these are things you have to look into because they can make a significant difference. If you're a non-resident and you're not taxed on foreign source income, that may be the right period to unwind certain assets, sell a house, sell some securities or bonds or mutual funds you have outside the US because you're not taxed on that. Whereas once you flip it and you pass 182 days, and you become a full-term resident, you're taxed on your worldwide income, including those foreign gains and assets.
What if you are a permanent resident, meaning you have a green card in the US, but you're spending less than half, you've spent, let's say in 2020, less than half the actual days physically in the US, which happened to a lot of people who were stuck overseas?
Well, that's where you come into a very strange exception or a fiction almost. If you're a green card holder, just the same like you're a US citizen, you're deemed to be a tax person in the US on residency, regardless of the time you spend in the US. Right? And the US is one of the 5 countries in the world, together with like Eritrea and New Zealand, that have that rule. Other countries don't have it. So they will chase you wherever you are in the US, and you have to file a tax return. And also you may end up paying US tax on money that you make overseas. Now, this is an obligation that you should not underestimate. Because in the US, they have a system that if you don't file a US tax return, the statute of limitation that normally happens when you file a return never starts. So the clock never starts ticking. Means if you are a green card holder and you leave the US, but you stop filing US tax returns, all those years remain open and the IRS can come in and actually tax you for that. And actually, when the IRS finds out that you haven't filed returns when you should have, they may even disallow you certain expenses, and now you're taxed on your gross income rather than your net income, which can be very painful, including penalties and interest. So the US forces people to comply by putting penalties in place. $10,000, $15,000, $20,000 penalty is not an anomaly in the system. Right. So you have to be aware of that even if you leave the US and you may be focused on the country where you are now and picking up your life over there, you still have those obligations you have to meet. And strangely enough, when it comes to green card holders, again, a green card holder has 2 major components. One is your work authorization, one is your tax obligation. It may well be that when you leave the US and you never surrender your green card, your work authorization will terminate after a year or 2 years. Your filing obligation never terminates, which basically means now you got the worst part, but not the perks. You can work in the US, but you got to file and pay taxes in the US.
Yeah, I mean, the US government considers it an abandonment of your status if you've been outside the US as a green card holder for more than 2 continuous years. In other words, two years and a day. But you have to actually proactively renounce it, or they will never know whether you're there or you're not. They're not going to keep track because they want to keep having that hold over you in terms of your requirement to submit taxes, right?
Correct, and that's the obligation you assumed when you got the green card. Is you're going to work under this fiction that wherever you are in the world, you're still going to be taxed in the US. So the most important part is when you are leaving the US is discuss between immigration and tax. What's the most opportune moment for you to surrender your green card in an active measure, right? And as I said, you have a up to 2-year window after you leave the US. You don't have to do it on the day that you leave. Right. This also allows for planning, and it also allows for timing, and it actually gives you time to calculate your most optimal outcome of whenever. It may be a difference between surrendering your green card in 2021 versus 2022. So then you can pick the best year for you. You can look at a year where you have less income or more income. Those are all things that come to play.
I think there's a lot of variations on this theme. One that I've seen is E2 executives and managers who don't need to be in the US full time in order to run operations in the US and overseas. They go back and forth. But what they don't understand is that there's a stipulated salary in their petitions and they're required to be paid that, which means the taxes should also be paid on that amount, regardless of how much time they're actually physically present. So a lot of them will say, well, I'm only in the US a quarter of the time, so I'm only going to pay myself a quarter of that salary. And it doesn't work that way.
Correct. No, that's another obligation you assume when you get that visa. So these are the part of requirements, and you cannot separate immigration from tax in this respect because they're kind of aligned. On the other hand, when you come in on an L1 and H1B, there are possibilities, if you do it right from the beginning, to maybe argue that you are a non-resident for a substantial period of time because you don't have the right to stay in the US. It's only for a temporary basis. And part of the residency test is the 182-day rule, which is very mathematical. But at the same time, they look at intent. And you can say, well, if you have never have the intent to stay in the US for a longer time because legally you're not allowed to, well, maybe it makes you just nothing more than a temporary visitor, and that by definition can bring you into non-resident status. Now, this is not something you do by yourself, but you can have this calculated if it makes any difference for you.
Fascinating, because they're supposed to be, especially L1s, they're supposed to be full-time visas. So it's very, very nuanced. So if people have questions about these issues and they're really not sure how to tackle them, they don't know how much time to spend, they don't know if they should transition, let's say, from a temporary visa to a green card and what the implications are, for example, how do they get in touch with you?
Well, they can reach me via email, which we're going to post here in the video, and also via phone. And mind you that, for a lot of people, taxes are completely outside their area of expertise. For me, what seems to be a very difficult question for you may be a very simple answer for me and can be answered in maybe 5 or 10 minutes.
Absolutely true. And that's why I send people your way, Mark, because I don't even want to try to understand. I just want to know that I'm putting my clients in good hands. So
same here. I mean, we are very much aware that there's an interaction between the IRS part and the IND part. And for a lot of people, there are two separate things. My visa status and my tax return are two separate things. No, they're not. They're connected. They're attached.
Very true. Thank you so much, as always, for your time and for your knowledge, Mark.
No, great to chat with you about this. Thanks for having me.